Mandamus lawsuit filed after USCIS delay passes. 3 years after years of inaction, immigrants turn to federal court. Let's take a look at this case. This is filed in the U.S. District Court for the Southern District of New York. I know it's an old case, but it's a pretty good example. Here is the petitioner, or sometimes referred to as the plaintiff. And then here are the respondents. And they have named quite a bit of U.S. entities or agencies as respondents, or usually referred to as defendants. And this is a petition for the writ of Mandamus. Okay, so here the petitioner is hereby petition for a writ of Mandamus to the U.S. Department of Homeland Security, the USCIS, and what are they looking for them to do? To compel further action or petitioner's form I-130, petition for alien relative. And the jurisdiction is the U.S., and they say the court has authority to issue declaratory and injunctive relief under a certain statute, 28 U.S.C. 2201 and 2202, and then name a couple rules from the Federal Rules of Civil Procedure. And then the parties. The petitioner is a citizen of the United States whose Form I-130. So the petitioner filed the Form I-130, which is the petition for alien relative, and they filed it on behalf of her spouse and is currently pending with the USCIS. And the respondent is sued in his official capacity as the Secretary of the Homeland Security. Again, this is in case is a couple years old. And then they're saying that as the Secretary is responsible for the administration and enforcement of the immigration laws of the United States. And the respondent is sued in official capacity as a director of USCIS. And so they name a couple other respondents here. Let's take a look at the statement of facts. Again, the petitioner is the U.S. citizen who filed the I-130, like we mentioned, for alien relative in 2018. And according to immigration benefit, so it's an immigration benefit, right, for her spouse. As a date of this filing, the instant petition for writ of Mandamus, the USCIS had not acted on the I-130 filings matter even after 3 years. So it's a 3-year delay, and they had exhausted all available administrative remedies. Petitioner to this date has contacted USCIS repeatedly to inquire about the status. At the time of each inquiry, she was advised that his petition is being processed. My question, is did they reach out to the USCIS ombudsman? Did they reach out to the congressman before filing this? I don't know. It doesn't say. To this date, petitioner has waited for almost 3 years for final decision on his immigration petition. Petitioner has no other administrative remedy by which she may seek the USCIS to more meaningfully address the delay. So basically, she's out of all the administrative remedies for processing the I-130 petition. And the cause of action is respondent has a duty to complete adjudication of petition I-130 petition within a reasonable period. Then it says, under the Administrative Procedures Act, the district court is vested with the authority to compel agency action which has been unlawfully or unreasonably withheld or delayed. Then it says that the agency's own regulation provides that processing of a case may not be withheld except in which an investigation has been undertaken. And then it says if a case is validly withheld, it may not be withheld for more than 1 year. If a case is withheld for more than 1 year, the district director must review the case and may grant only 2 6-month extensions where appropriate. if the investigation is not completed by second anniversary, the case must be referred to regional commissioner. The petitioner has a clear right to seek the USCIS for the immigration benefit for the spouse. Respondent in this case is unreasonably or unlawfully delayed in processing I-130. No legitimate reasonable ground for not finishing the processing. The USCIS, the official website, does have some processing times. I mean, at that time when they were filing, they say that I-130 in the category of filing for the spouse was taking anywhere between 8 to 10.5 months. I mean, if you look at the website now, it's much higher right now. And what they're requesting from the court is to issue a writ of mandamus to compel the respondents to complete processing and adjudicate the petitioner's Form I-130 without further delay, and declare that respondents have a duty to complete the processing of the petitioner's Form I-130 in a prompt manner without further reasonable delay. Again, these are public records that are in the court, and we're just looking at them to see what does a writ of mandamus look like, and what does the individual petitioner have to go through to get certain things approved when they're not moving along. All right, thank you so much.